Hi, welcome back. Today, in this session, we are going to discuss about authorities under Industrial Dispute Act of 1947. The Industrial Dispute Act is a law which is intended to investigate and settle industrial disputes. The Act constitutes certain authorities for the purpose. Works Committee. It must be constituted in an industry where 100 or more workmen are employed or had been employed in any day during preceding 12 months. The appropriate government is competent by order to direct the employer to form a works committee. It consists of the representatives of the employees and the workmen engaged in the establishment. It shall be the duty of the works committee to deal with the measures to preserve amity and cordial relation between to deal with the measures to preserve amity and cordial relations between the employer and workmen. It has to comment upon issues of common interest and to make a sincere attempt to solve it. The Works Committee's opinion, though carrying great weight, is not binding and conclusive. So, the Works Committee's opinion is not binding and conclusive. In words of Justice Das Gupta, the Works Committee has to smooth away friction between employer and employees. The values of the decision of the Works Committee is very little in its practical point of view. In Kemp and Co. versus the Workmen, 1955, the Supreme Court held that although the decisions are not conclusive, they do have great weight in creating an atmosphere of settlement. Now, the next one is conciliation officers and board of conciliation. That is section 4 and section 5. Section 4 of the Act empowers the appropriate government to appoint conciliation officers. It is discretionary on the part of the appropriate government to appoint conciliation officers. If the government is not willing to appoint conciliation officer, a writ will not lie. Now, his duty a conciliation officer, his duty is to mediate and promote the settlement of industrial disputes. The function of the conciliation officer is not judicial but administrative in nature. It was also held in Jaswant Super Mills versus Lakshmi Chand, that is 1963. So it was also held in Jaswant Super Mills versus Lakshmi Chand that the function of conciliation officer is not judicial but administrative in nature. Section 5 of the Industrial Dispute Act empowers the government to appoint a board of conciliation. It shall consist of a chairman and 2 or 4 other members as the government thinks fit. The chairman shall be an independent person and the other members shall be persons appointed in equal numbers representing each party. Quorum is necessary for its proceedings. A board shall not function in the absence of chairman. Where a dispute is of complicated nature, the issues involved are important and require special handling, boards are preferred. However, in recent years, no board has been constituted by the central government. Now, the next authority is Court of Inquiry, that is Section 6 of Industrial Dispute Act. Section 6 of Industrial Dispute Act empowers the appropriate government to appoint a court of inquiry for inquiring into any matter connected with industrial dispute. It consists of one member or as many members as the government thinks fit. Quorum is necessary. It can function even during the absence of chairman, provided the quorum is satisfied. The remedy under Articles 226 and 32 are available to a party agreed by the decision of the Court of Inquiry. So that was held in Leelavati versus State in 1987. In the case Leelavati versus State 1987, Supreme Court held that the remedy of writ jurisdiction that is available under Article 226 and Article 32 are available to a party agreed by the decision of the Court of Inquiry. During the pendency of the proceeding before a court of inquiry, there is no bar against workmen going on strike. So there is no bar against workmen going on strike. Now, similarly, there is no bar against lockout either. So even when the proceedings are pendent in the before the court of inquiry, the workman can go on a strike or the employer can have a lockout. There's no bar for either of it. Now the next authority is Labour Court, that is discussed in Section 7 of Industrial Dispute Act. The Industrial Dispute Act is an act intended to settle industrial disputes in India. The act itself provides certain statutory bodies for the settlement of industrial disputes. Labour Court is one such statutory authority constituted by the act. By virtue of Section 7, the appropriate government has the power to constitute one or more labour courts in any state. The subject matter which the Labour Court is competent to adjudicate are enumerated in the second schedule of the Industrial Dispute Act of 1947, and they are as follows. 1. The propriety or legality of an order passed by an employer under the standing order. 2. The application and interpretation of standing orders. 3. Discharge or dismissal of workmen, including reinstatement of or grant of relief to workmen wrongfully dismissed. 4. Illegality or otherwise of a strike or lockout. And 5. All matters other than those specified in the third schedule. The Labour Court consists of an officer who is having the status of a High Court judge or has been a district judge or additional district judge for not less than 3 years, or has been the chairman of any member of the Labour Appellate Tribunal or of any tribunal for not less than 2 years, or has held any judicial office in India for not less than 7 years, or has been the presiding officer of a labour court under any provincial act or state act for not less than 5 years. Now, tribunal. Tribunal is discussed in Section 7, Clause A, 7A of the Industrial Dispute Act. So, Labour Court is discussed in Section 7 and Tribunal is discussed in Section 7A of the Industrial Dispute Act. Deals with the constitution of the Industrial Tribunal. It has the power to adjudicate those matters which are covered in Schedule 2 or Schedule 3. So, tribunals have jurisdiction over matters in Schedule 3 too. Now, he must be a person who is or has been a judge of the High Court or a district judge or an additional district judge for not less than 3 years, or who has held the post of a chairman or member of the Labour Appellate Tribunal or of any tribunal for a period of not less than 2 years. The appropriate government may, if it so think fit, appoint 2 persons as assessors to advise the tribunal in the proceedings before it. Section 10 of the Industrial Dispute Act empowers the government to refer an industrial dispute to the Industrial Tribunal. The policy of the legislature was to confer jurisdiction to adjudicate disputes arising from matters in the Schedule 2 and 3. The functions and duties of the tribunal are of quasi-judicial nature. In Bharat Bank Limited versus its employees, that is 1950 case, Bharat Bank Limited versus its employees, the Chief Justice Kania observed that tribunal is discharging functions very near to that of a court, although it is not a court in the technical sense of the word. So that was held by Chief Justice Kania in Bharat Bank Limited versus its employees in 1950. Now the next authority is National Tribunal, that is discussed in Section 7B. The central government may by notification appoint one or more national tribunals for the adjudication of the industrial disputes. The dispute must be a dispute which involves question of national importance. It consists of one person only to be appointed by the central government. The central government may appoint 2 persons as assessor to assist the national tribunal. So, with respect to the authorities, we have Works Committee, and then we have Conciliation Officer discussed under Section 4, then Board of Conciliation discussed under Section 5, then we have Court of Inquiry discussed under Section 6, then Labour Code under Section 7, then Tribunal or Industrial Tribunal under Section 7A, then we have National Tribunal under Section 7B. These are the authorities under Industrial Dispute Act, and that is the end of this session. Thank you for listening. Like, comment and subscribe. Don't forget to click that bell icon so that you get an update or a notification when I upload my next video or a podcast. Thank you for your support.